Welcome to this video on the Mine Health and Safety Act and the Occupational Health and Safety Act, focusing on legal liability. We begin with a look at the Mine Health and Safety Act. Our safety policy states that health and safety is non-negotiable. We endeavor to staff the company with competent employees, ensure continuous hazard identification and risk management, and support the philosophy that both management and employees are responsible for health and safety. Management believes every employee has the right to a safe and healthy environment and the duty to withdraw from a dangerous situation. You should stop, fix the issue, and then continue working. Our vision is to be pioneers in empowering the community with credible, sustainable, and marketable industrial skills. Our mission is to polish the many facets of the human diamond through excellence in the provision of credible training. In the introduction, an employer has legal and moral obligations to safeguard employees against injuries, diseases, and risks to health and safety. These risks must be managed and controlled, as failure to do so can lead to prosecution. In the event of a prosecution, the employer must prove they actively participated in health and safety, issued directives with evidence, held meetings with available minutes, conducted documented management audits, and kept up-to-date, secure training records. Focusing on the Mine Health and Safety Act, an employer must prove several things in case of prosecution. These include active participation in health and safety enforcement, issuing directives with evidence, and holding documented meetings. Under the reasonable man test in common law, the court judges the act or omission of the accused. Omission equals neglect. Negligence is proven if a reasonable person in your position failed to foresee or prevent harm, or if your action deviated from that of a reasonable man. Legislation requires every person to act like a reasonable person when maintaining health and safety. Sources of criminal liability include common law and legislation, such as the Occupational Health and Safety Act and the Mines Health and Safety Act. Employee awareness is stimulated by major disasters, such as the Val Reefs mine and the Lenasia factory incidents. Acts also create a standard, ensuring people know the rules and work accordingly, and bringing irresponsible people in line. Safety, health, and environment legislation ensures no worker is endangered by the employer's activities. Main features include regulating health and hygiene, providing training, electing safety reps and committees, and taking steps to prevent accidents. Safety, health, and environment legislation applies as a general rule in all employment activities and machinery usage. Requirements pertain to workplaces ranging from mining to residential homes. The objectives of the Act include providing training, establishing an advisory council, identifying and controlling risks, and providing for employee participation through safety reps and committees. They also cover effective monitoring and enforcement of health and safety measures. The Mine Health and Safety Act aims to promote a culture of health and safety, provide training, and encourage cooperation and consulting on health and safety among the state, employer, employees, and representatives. An employer is a person who provides work and undertakes to pay another person for services provided. An employer also gives instructions or supervises another person. Employer duties include providing a safe and healthy working environment, suitable systems of work, machinery, and equipment. They must also eliminate or control risks, determine preventative measures, and provide information and training. Employers must not permit work without necessary precautions. Employers must ensure compliance with legislation and that work is supervised by a trained and competent person who addresses hazards. They must also ensure that persons understand their tasks and that no one is exposed to hazards. Workers must be trained to understand risks and precautions. Workers must cooperate with the employer to ensure compliance with SHE requirements. They must take reasonable care for their own and others' safety, follow lawful instructions, report unsafe conditions or incidents, not misuse equipment, and may withdraw from the workplace if they believe there is a danger. Competency is defined by general competencies, which include knowledge, skills, experience to organize work, familiarity with legal provisions, and training to recognize potential dangers. Certificated competency requires supplementary site induction for those with formal qualifications, but who may not understand site-specific hazards. SHE legislation requires all employees, especially new appointees, to be competent, as appointments without competency are of little value. A legal appointment consists of more than just a form, including consideration of appropriate legislation, other health and safety requirements, and the company's safety and health system. The inspectorate has powers to enter premises without notice, question anyone, collect documents, inspect work conditions, instruct persons to appear for questioning, remove items for analysis, and perform any other function. To comply with minimum standards, use legislative tools such as company rules and regulations, risk assessments, proof of training, written safe work procedures, task observations, inspections and registers, and proof of disciplinary action. No person may start work until fully inducted, trained, and found competent. This includes health, safety, environment, fire, and emergency procedure training. Employees must understand the risks of their work and necessary precautions. Refresher courses are vital due to continuous changes. Occupational health and hygiene requires the workplace to be healthy and safe. This involves normal risk assessments for safety hazards and a hygiene surveillance program to monitor conditions that can make employees unhealthy, such as chemical hazards like vapor, gas, smoke, dust, and fume. Physical hazards include noise, temperature extremes, illumination levels, vibration, and radiation. Biological hazards consist of bacteria, viruses, fungi, and parasites. Medical surveillance assesses the effects of hazards on employees, including reduced lung function, loss of eyesight or hearing, muscular movement issues, heartbeat, and overall fitness. A manufacturer is anyone who designs, makes, imports, sells, supplies, erects, or installs any article or substance at a workplace. Their duties include ensuring the article is safe and that erection or installation poses no risk to health or safety. Manufacturers of hazardous substances must ensure safety and provide information on proper storage, potential risks, restrictions, safe precautions, emergency procedures, and disposal of waste. Under the Mine Health and Safety Act, regarding personal protective equipment, you must establish hazards, take precautionary measures, and reduce or eliminate hazards before resorting to PPE. Do not permit work without precautionary measures. Keep written records for the issuing of PPE and training in its use. Ensure PPE is available and serviceable. Contractors have the same legal liability as an employer. Report accidents that entail medical expenses or more than 3 days of absence from work. When reporting an accident, complete Part A of Form WCL2, detach and provide Part B to the hospital or doctor, complete Part A page 2 fully, and forward the completed Part A to the Commissioner. Penalties for an employer found guilty of non-compliance can result in a fine of $50,000, imprisonment for 1 year, or both. This penalty may apply if an employer fails to comply with certain sections of the OHSA, notices or exemptions, or if they hinder an inspector or tamper with safety equipment.